Hi, good evening and welcome.
Thanks. My name is Alec Stratford. I'm the Executive Director Registrar with the College of Social Workers. You can call me Alec. I'll let...
I'm Valerie Heard. I'm the Professional Conduct Manager for the Nova Scotia College of Social Workers, and you can call me Valerie.
All right, thank you both for being here. I'm going to start your time in a moment, and then, sorry, do you have a question?
We're going to be kind of jumping back and forth. Is that going to be a problem technically?
No,
Okay.
I think we should be fine. Yeah.
Okay.
You only get 15 minutes total.
Yeah, I get you. Just wanted to make sure. Okay.
All right, thank you. Go right ahead.
Good evening, everyone. Really happy to be here to speak on behalf of the Nova Scotia College of Social Workers regarding Bill 36. I do want to recognize that although we are attached to the Nova Scotia Regulated Health Professions Network and do endorse the recommendations they've been made forward, we are not legislated under PACA, so any amendments that are exclusive to PACA would not include our college. So it's important to note as we move forward. We really want to take the time tonight to talk about the regulatory oversight and the impact that Bill 36 could have. So like many regulators, the college exists to serve and protect Nova Scotians, particularly our most vulnerable populations. We do this by upholding the highest professional and ethical standards and advocating for social policies that enhance the ethical and safe delivery of social work. Social workers are entrusted with the well-being of children, families in crisis, and individuals facing systemic barriers, and they provide life-saving interventions and support to those in greatest need. Now, for over a decade, the college, alongside its counterparts across Canada, have worked to enhance labour mobility within the profession, ensuring the regulatory framework remains both efficient and rigorous. I've been to this committee before talking about some of those, so I won't take time tonight to go into much detail there, because we want to talk about the impact. Bill 36, we believe, doesn't move us forward. It does set us back, as it threatens to weaken professional oversight, lower standards, and introduces unacceptable risks to the very people our profession is meant to serve. Perhaps most concerning is that we were not consulted on this bill or the impact it might have on the most vulnerable in our society.
As regulators, our primary role... As regulators, our primary role is to ensure that every social worker practicing in this province meets the qualifications, ethical foundation, and competency necessary to serve Nova Scotians safely. Bill 36 would restrict the ability of the Nova Scotia College of Social Workers to uphold professional standards for social workers practicing in our province. Our primary role is to ensure that every practitioner, regardless of where they are trained, meet the qualification, ethical standards, and competency expectations necessary to serve our communities safely. Under this bill, social workers from other provinces could practice in Nova Scotia without registering with the college, bypassing oversight mechanisms designed to ensure that all practitioners possess the necessary education, character, and competence to perform complex social work services. This is especially alarming given the critical shortages and increased pressures in sectors like health and mental health and child and family well-being. Take, for example, the variation in educational standards across provinces. Nova Scotia, like most provinces, mandates that social workers graduate from Canadian Association for Social Work Educating accredited degree programs, ensuring rigorous research-based training in psychosocial interventions and systemic advocacy. In contrast, Alberta also permits diploma-trained social workers to practice. Individuals whose training is less comprehensive and lacks the depth necessary for the full scope of professional practice. This is why almost every province has a legitimate objective under Canadian Free Trade Agreement not to have automatic registration of diploma graduates. Social workers are the backbone of our child and family well-being systems. They intervene in the most complex and emotional moments of life, from ensuring the safety of a child at risk to supporting families in crisis. These are not roles for the untrained or the unaccountable. They require expertise, integrity, and a commitment to public trust. Ensuring public trust in professional services is not just about qualifications, it's also about accountability when things go wrong. Professional oversight exists to protect both service users and practitioners, ensuring that misconduct is addressed swiftly and fairly. However, under Bill 36, this accountability is severely weakened. As currently written, Bill 36 allows social workers from other provinces to practice in Nova Scotia without registering with the NSCSW. This means that if misconduct occurs, the college will have no authority to investigate or discipline those people. And at the same time, their home regulatory body will also lack jurisdiction as the misconduct happened outside of their province. This creates a dangerous accountability gap where harmed individuals have no clear path to justice. The risks here cannot be overstated. Bill 36 does not even require the NSCSW to be informed of an out-of-province practitioner's disciplinary history. In high-risk fields such as child protection, mental health, swift action is often needed to safeguard vulnerable populations. Without access to social workers' professional conduct record, the NSCSW cannot adequately assess risk or make informed decisions about fitness to practice. This is not just a regulatory gap, it is a direct threat to public safety. Beyond public safety, this lack of oversight also raises serious liability concerns for the government and service providers. If harm does occur due to misconduct, who is it that's going to be responsible? In the absence of a structured complaints process, taxpayers, businesses, and social service organizations could bear the cost of preventable failures. The impact of this bill extends beyond individual cases. It undermines confidence in potentially in our entire profession. Between 2020 and 2023, our college processed over 150 complaints, which highlight serious concerns in key practice areas, including child welfare, healthcare, and private practice. Under Bill 36, complaints involving out-of-province practitioners would be nearly impossible to address. Service users would be forced to navigate unfamiliar regulatory systems, adding yet another barrier to justice, particularly for marginalized individuals already facing systemic challenges.
Coming back to me, one of the reasons why regulations are placed within provinces is because we do have unique cultural, economic, and social aspects of our province. For instance, in Nova Scotia, we've been a leader in addressing historical and systemic injustices, particularly for African Nova Scotians. The NSCSW has been updating our Code of Ethics and Standards over the last 5 years, and we're just about to implement a new framework in April, which reflects, in particular, Afrocentric and reparative lens that acknowledges the specific needs of African Nova Scotian communities. These standards are not found in other provinces' regulatory frameworks because they are unique to Nova Scotia. Bill 36 would allow out-of-province practitioners to operate in Nova Scotia without being held to these critical principles, ultimately rolling back progress towards equity and culturally responsive service delivery. Imagine a scenario where a social worker from another province, unfamiliar with Nova Scotia's Afrocentric principles, unknowingly dismisses or misinterprets the lived experience of an African Nova Scotian seeking support. Without alignment to Nova Scotia's specific ethical standards, these individuals are left without culturally responsive care, and those concerns may not be adequately addressed through complaints or discipline process. We're going to flip back over here.
Yeah, that's me. The Mass Casualty Commission report recognizes a reality that many of us in regulatory and public service already know initiating a complaint can be an overwhelming burden, particularly for marginalized individuals. Navigating bureaucracy, understanding legal rights, and overcoming institutional barriers often deter vulnerable individuals from seeking justice. Bill 36 makes these barriers even worse. Under this bill, a Nova Scotian receiving services from an out-of-province social worker would need to access that worker's home regulatory body. For many individuals, this is an insurmountable obstacle. It means dealing with unfamiliar complaint process, different legal frameworks, and regulators with no knowledge of Nova Scotia's unique needs. Beyond the harm to individuals, weak regulatory oversight creates liability risks for the province. Without clear accountability structures, Nova Scotia could face costly legal challenges if residents suffer harm due to professional misconduct without accessible recourse. Accountability isn't just about ethics, it's about good governance and fiscal responsibility. We must ensure this bill protects not just individuals, but also the integrity of our institutions and the financial stability of our province.
So we all want a system that promotes professional mobility, and I can say with confidence that social workers across the country have worked towards this goal. We also want to make sure that we have a province that is delivering the highest quality of care, and we shouldn't need to choose between efficiency and accountability. We can do both, and I believe we have. Simplifying processes should not mean providing safeguards, should not mean removing safeguards. Other provinces may have different priorities, but Nova Scotia has consistently led in maintaining strong provincial oversight and equitable service delivery and social work. This bill, as written, undermines that leadership and introduces uncertainty into the critical fields that social work provides care in, including child welfare, health care, and mental health as well. The college's statutory mandate entrusted to us by government is to protect the public interest of Nova Scotians, who are the most vulnerable, access social work service. By stripping the college of its powers to effectively regulate, Bill 36 critically undermines our ability to fulfill this mandate. We urge the government to consider these risks and amend the bill to ensure and maintain oversight, guaranteeing the complaint process remain local and accessible, to uphold Nova Scotia's right to enforce its ethical and professional standards, and remove barriers that prevent marginalized communities from accessing justice. I urge you to take these concerns seriously, because once we weaken professional oversight, restoring it will be significantly harder. So we hope that we can take the necessary steps to correct this bill.
Thank you both very much. I'm going to ask for questions from MLAs, beginning with MLA Rankin.
Thank you, Mr. Chair. And I just want to be clear that the interpretation of Bill 36 is that overrides your existing regulatory authority, and that you did not have an audience with the minister or his staff, the Minister of Trade being the Premier. And I asked that question because the previous presenter did say they had an audience with that minister and that there is amendments coming. And I got to say, before you answer the question, that that's a problem, guys. And I would implore government members to table any amendments that are forthcoming, so that we actually have a true picture of which organizations will have an exemption to the overriding authority of this Bill 36 that's before us. So we have a very important profession here is social work that's related to our most vulnerable Nova Scotians, and the question really is, have you been consulted, and is your understanding that Bill 36 will override your existing authority to regulate, and are you aware of any, I know that's 3 questions, but I only get 1, so are you aware of any amendments that will solve that issue for you?
So
I'll recognize Alec, please.
it's the as previous presenters had mentioned, it's the absolute language in it that you don't have to register, you're just considered registered, that overrides our authority, right? If we don't have the registration of a particular social worker, then we have no authority to govern them. That governance would come from their home regulatory body, and as stated, there are significant gaps in accountability when that's the case. For instance, I talk to my counterparts, even if I'm a social worker registered in New Brunswick and I come here and there's professional misconduct allegations, well, here, any Nova Scotian that goes to New Brunswick, the New Brunswick registrar is going to say, well, that happened out of our jurisdiction. So we don't have accountability, nor would we. So in terms of consultation, the College of Social Workers, as social work does itself, is in many spaces. So we are a member of the Nova Scotia Regulated Health Professions Network, so we were involved in the consultation with the Premier. However, as I mentioned at the top, the amendments that we understand are going to be related to the Patient Access to Care Act, which we are not governed by. So any amendments that are specific to PACA, our college would not be impacted by those. I think I got all your questions.
Thank you very much. I recognize MLA Wilson.
The other MLA was ahead of me, so please go ahead.
I recognize MLA Benexon, please.
Thank you, Chair, and thank you to my colleague. And I want to thank Alec and Valerie for your presentation today. Can you describe how you currently recognize and vet credentials from other provinces? So there must be people applying to come to Nova Scotia. So how would you do that? And then,
So as I mentioned, or as we mentioned in our presentation,
I'm going to recognize you, Alec. Thanks.
Apologies. As we mentioned in our presentation, every jurisdiction in Canada uses the CASWE accredited degree as the baseline for qualifications in Canada. That makes labor mobility very easy. right? Because we're all along those same that same qualification, except for, as we mentioned, Alberta, which has diploma registered graduates, which is why we have legitimate objectives under the CFTA. As I mentioned, every other province has that same objective. So in terms of what mobility looks like, you fill out an application form. You have your home jurisdiction fill out a verification form that you're registered with them. You pay a fee, and then you're registered in Nova Scotia. We also, sorry.
We have 30 seconds. I recognize MLA Wilson next.
Request, I'm going to speak very quickly. As you aware, there's the Universal Mental Health Program coming in. Are social workers going to be included in that program? And if they are, could they come into province and practice in that program without your knowledge?
Under Bill 30, sorry, Chair.
I'm going to recognize Alex again. Alec.
Under Bill,
I am going to have to say order. Our time is up.
okay.
Thank you both very much.